Good evening. Good evening. I am deeply honored Justice Santosh Hegde is here. Uh, he was present and he launched my very first book in 2004. So I'm really, really honored, sir, that you're here. Uh, uh, Dr. Aditya Sondhi is also very kindly requested to be on the panel. And Dr. Radhika Chitkara has agreed to moderate. A very warm good evening to all of you for being here. Very often I'm asked, why did we name this book Incomplete Justice? So the answer is that our experiences of the Supreme Court, whether as judges, lawyers, litigants, are vast and varied. Not everyone leaves a court satisfied that justice has been done in a case. And when you look at 75 years of an institution, one will find many instances where even a lay observer, not involved in the proceedings, will sense that what's been done is either incomplete or inadequate. There's a tendency for institutions when they look back at their own performances, whether they are the high courts or the Supreme Court, whether at the end of 10 years, 20 years, 50 years, they tend to be largely self congratulatory. They tell you about what they've achieved. Very rarely do they really introspect and examine what are the fault lines. We felt that an occasion of 75 years of both the Constitution and the Supreme Court is good enough for us to undertake that exercise. And that's the reason why the book is called Incomplete Justice. Another explanation could be that under our Constitution, there is one provision, Article 142, which empowers only the Supreme Court of India, not the High Courts, and definitely not the district courts, to pass orders which it considers necessary in the interests of complete justice. And as observers of the Supreme Court, as judges, lawyers, legal scholars, many cases we find are decided on the basis that although the facts of the case don't justify it, or perhaps even the law does not mandate it, the Supreme Court still goes ahead and passes an order using these powers that it has under Article 142 of the Constitution. And we find that although it is intended to do complete justice, it can actually contribute to less complete justice. So these are the broad explanations for the title. And the word critical reflections that we've used there is precisely for the reason I mentioned, that we need for institutions to become introspective and for us to step back and see where the court has perhaps not fulfilled its mandate. And the entire purpose of this book is to generate a debate and discussion. A person reading this book may have different points of view, may have different interpretations of what happened, but that is to be welcomed. If we have to be a vibrant democracy, we must welcome dissent, we must welcome differences of opinion, and we must learn to provide that democratic space where the debate can be conducted in a civil manner. So that's another purpose of this book, is to generate that debate. People have also asked me about the book cover. The designer is Antara, and the explanation is this. The original design of the Supreme Court building is supposed to resemble a balance, with the central dome being the top of the balance and these two being the scales. And that's what we've tried to capture. The new building that's coming up on the right corner, that's where Apugar used to stand earlier, and now you have the administrative blocks. Right behind the central dome, right now, a huge construction is going on for additional blocks, which will probably get readied in 4 or 5 years' time. I've got an introduction, I'll come back to that later, but we have through the book 17 cartoons by 6 eminent cartoonists. One of them, Rachita Taneja, is present here. Thank you, Rachita, for contributing 5 of your creative artworks to this book. And each of them has been quite generous in letting us use the cartoons. So in the first part, we have court and its actors. And one of the first chapters is by Justice A.P. Shah on judicial appointments. He traces the whole history of how the primacy has shifted from the executive to the judiciary, and not quite in the way it is actually worked out in the last few years. Complementing that chapter is the next one by Justice Madan Lokur. We have, of course, interspersed these chapters with cartoons. This talks about the problem of inadequate representation on the court by all interest groups. Justice Lokur speaks as an insider who's been part of the collegium. He tells us how collegiums work both in the high courts and in the Supreme Court. He comes up with concrete examples and makes a very strong point about having a proper documentation, why a secretariat is necessary both in the high courts, in the offices of the Chief Justices of the High Court, as well as the Supreme Court of India. Then we have Raju Ramachandran, the senior advocate, talking to us about removal and disciplining of judges. And this cartoon, of course, Pencil Ashan is a person nothing to do with the law. He pursues cartooning as a hobby, and he's in the Middle East. And I think he's captured wonderfully the bar and the bench, how they look at this. See, look at the quote on top. This is the Bar Council of India, which is another problem that we face today in the country, that the bar has ceased to exercise its independence. So that's a serious problem that we have. I'm sure will come up in the discussions we're going to have. Usha Ramanathan talks about judicial delay and pragmatism. She again brings up concrete examples of how, because of the delay in deciding cases, particularly like demonetization or electoral bonds, the Bhopal gas disaster and so on, how there is a grave miscarriage of justice just because of the delay, and these are avoidable delays. This is the cartoon by Satish Acharya, which explains again the problem. Rohan Alva talks about the constitution benches, benches of 5 judges or more, how they are constituted, what kinds of cases they decide, and the problem with assuming that once a 5-judge bench decides a case, that is the final view of the Supreme Court. And he demonstrates how it need not be the final view and how quickly it can get overturned. This is Satish Acharya's another cartoon on demonetization. That hand sticking out reminds us about more than 110 people who died waiting in the queues to change the demonetized notes. Justice Ravindra Bhatt has spent this chapter on the administration of the courts. This is something people rarely talk about or know about. The difficulties faced by the judges who have to double up, not just merely decide cases in court, they have to double up as administrators, as managers. They have to become persons who will be the experts in deciding which kind of computers will be bought for the court, how to balance the budgets of the court, how to oversee infrastructure, projects, and so on and so forth. And the tremendous pressures that therefore they work under. Social action litigation, which is Professor Upendra Bakshi's title for public interest litigation. And this is something that he's at pains to point out for the last 40, 50 years, that we are making a mistake in calling it public interest litigation. We should actually be calling it social action litigation. I've conducted an interview with him and with Indira Jaisingh. At the end of this chapter on court and criminal law and practice, we have 3 eminent senior lawyers who've given us chapters, Rebecca Mammon John, Nitya Ramakrishnan, and then Vrinda Grover. They talk of various aspects of criminal law. And then we have court inequality, where we have Professor Faizan Mustafa speak about minority rights, Article 30, institutions run by the minorities. Then we have a chapter by Professor Mohan Gopal. So this book has contributions by judges, senior lawyers, academics, senior academics, and even a journalist. So this chapter by P. Sainath, the veteran journalist, is remarkable in its clarity, and brings before us the viewpoints of laypersons. How do laypersons look at the court as an institution meant to deliver justice? And this cartoon complements Sainath's piece perfectly well, and this is the point he's actually trying to make, that the court does not seem to be working for the less privileged in India. Indira Jaisingh is a senior lawyer who's been practicing before the Supreme Court of India itself for more than 5 decades. And in my interview with her, she gives us useful insights into not only how the profession is today ordered, but how in individual cases judges have either displayed open biases that they have or have tried to transcend those biases. This is one of Rachita's cartoons. The many of 5 of them are there in the book, where I think many in this audience would identify with what she's trying to say. I'll just go back for a minute. When a woman says, I'll do whatever it takes to win a case, she's labeled as being an aggressive lawyer. And then we have a whole chapter on substantive laws. I must enter a caveat here. There are many topics which we couldn't cover in the book. That's because of the size of the book. It couldn't go beyond 600 and odd pages. That itself is quite a large volume. And each of the essays couldn't go beyond 8,000 words. So these were the limitations why many topics which people feel should have been included could not be included. So Justice Chandru talks of labor law, Justice Gautam Patel on environmental law. And these are authors. I'm also asked, why did we choose these kind of authors? One criteria definitely was that these are all fearless thinkers and fearless writers. And we need that degree of fearlessness when we're commenting, when we're critiquing the functioning of the court. Second is, you need a certain degree of irreverence. You know, the way the whole judicial system is ordered, everybody is my lord, everybody is a jurist, everybody is a great thinker, everybody will be sorely missed if that person is no longer in the court. So there's no difference between one judge and the other. So you need a certain degree of irreverence, and I think these authors bring that to fore. And this is a cartoon by Rohan Chakravarti. Many of you readers of the Hindu will watch his cartoon come every Sunday. It's a brilliant cartoon. I don't have time to dwell on it. Senior lawyer Arvind Datar speaks of the tax landscape. Brilliant scholar Gautam Bhatia, who's both an author and a practicing lawyer, tells us about media freedom. And Surit Pasadi talks about the 10 schedule and its failures, and how the court is actually a political actor. It's not that neutral body or non-partisan body that we imagine it to be. It definitely makes deliberate political choices. That comes through in Surit's piece. Then we have Amit George, who talks of arbitration law. We have a chapter on the bar. We have an interview with senior advocate Meenakshi Arora on the functioning of the bar, the system of advocates on record in the Supreme Court. We have Gopal Subramaniam, senior lawyer, reflect on the kind of lawyers he has seen. So people will want to know the good news about the bar, you should read Gopal Subramaniam's piece. Kamala Shankaran, Professor Kamala Shankaran, who teaches at NLS Bangalore, head of Kamala is here. She's penned this chapter on legal education. And we reflect on court and its future because of the work of digitization that happened in Orissa when I was Chief Justice there. And earlier I was associated for a long number of years in the Delhi High Court's computer committee. So I've shared my ideas on digitalizing the judiciary. And this cartoon captures, the recent phenomenon post-COVID of hybrid hearings, of live streaming and all of that. And Sriram Panchu, a senior lawyer, shares his thoughts on mediation, on arbitration, and the future of the court. So this is about the book. The idea is that we throw open ideas, we throw open questions. We want people to think about it. We want people to reflect on it. We want people to discuss it, and without fear of contempt. And that's the whole idea of the book. I hope you enjoy reading it. Thank you very much. I know it will be late later, but apart from thanking each of the contributors who contributed to the book, I also wanted to thank each of the cartoonists who contributed to the creative works, and my 2 young associates, Nini Susan Thomas and Maitreya Subramaniam, who assisted me in editing the book. And I want to thank each member of the audience, apart from each of the panelists who are present here. Thank you very much. Thank you.
Thank you, Dr. Muralidhar, for taking us through this very exciting compilation of essays looking back at 75 years of the Supreme Court. I'm very excited to be here today, not only because we get to discuss this exciting compilation with with a panel of extraordinary lawyers and judges with decades of practice at the bar and the bench, but most importantly because we get to do this at a public forum. As lawyers, we tend to be very possessive about the law and legal institutions. But this book and this event specifically remind us that the Supreme Court is as old an institution, 75 years, as our constitutional democratic republic of India. And so, conversations about the functioning of the Supreme Court, concerns of appointments, transparency, independence, its doctrinal precedent, are relevant not just in seminar halls and our classrooms and the corridors of court, but more importantly, for the demos of the democracy. This book is not the first attempt at such a retrospective of the Supreme Court. In 2004, retired Justice of the Supreme Court and 4 other senior advocates had similarly attempted a compilation of essays looking at 50 years of the Supreme Court back then, right? And that book stands out really starkly still in my mind, because that was how, as law students, we were introduced to our constitutional law courses. And that book, of course, was called Supreme But Not Infallible. And I find that Dr. Muralidhar's book in some ways continues the same tenor of critical reflections through incomplete justice, critical reflections on incomplete justice. And of course, this book also pushes the envelope further. In some ways, the concerns that both these compilations took up, right, in terms of the role of the Supreme Court in delivering on questions of rights, constitutionalism, and social justice, that concern at some level remains common to both these attempts at the 50-year milestone and the 75-year milestone of the Supreme Court. But this book pushes the envelope further by addressing the sort of emerging concerns, raging concerns of the past 2 to 3 decades, specifically those relating to concerns of appointments, independence, accountability, the institutional functioning of the Supreme Court, the role of the Chief Justice, legal education, criminal law, doctrinal evolution in criminal law, taxation law, and other subject-specific concerns by judges, practicing advocates, and even a journalist. I was personally very happy to see a journalist appear in the table of contents, right? So, without further ado, I'd like to invite the panelists for today's discussion. Very happy to have Justice Hegde join us today. I invite you to please join us on the stage. Justice Hegde, of course, retired. Justice Hegde retired as a judge of the Supreme Court in 2005 after serving about 6 years on the bench. Prior to his elevation, He had served as the Advocate General for Karnataka from 1984 to 1988 and the Solicitor General of India from 1998 to 1999. After his retirement, he was appointed as the Lokayukta in Karnataka, a post he held from August 2006 until his resignation in August 2011. So, welcome, sir, and thank you for joining us today. I also invite Dr. Aditya Sondhi, uh, fellow alum of the National Law School, Bangalore. Dr. Sondhi is a senior advocate at the Supreme Court of India and has previously and continues to also practice at the Karnataka High Court. He has served as the Additional Advocate General for Karnataka from 2016 to 18. Dr. Sondhi is also an illustrious writer and playwright. His last book, I believe, took up the relationship between the military and democracy in India and Pakistan. And his play Famagusta was shortlisted for the Sultan Padamsi Playwright Award in 2020. Welcome, Dr. Sondhi. And of course, finally, Dr. Muralidhar. Needs no introduction, but he's the editor of the book. He's now practicing as a senior advocate before the Supreme Court of India, after having served as the Chief Justice of the Orissa High Court and a judge on the Punjab and Haryana High Court and the Delhi High Court for several years. So thank you for joining us and welcome. I'll quickly lay out the format for our discussion over the next 1 hour. So we'll start with some preliminary opening remarks for about 10 minutes each by Justice Hegde and Dr. Sondhi. To allow them the space to reflect on the book and their own experiences as a judge and members of the bar before the Supreme Court and the High Courts. After which we'll follow that up with a moderated discussion, a Q&A session, and finally, after 7 o'clock, a book signing right outside the doors of this seminar hall. And while we'll certainly conduct this as an exercise in reflection, like Dr. Muralidhar pointed out, I personally am very keen for today to also be about storytelling. When we think about lawyers, when we imagine lawyers, we think of them as, towering individuals in black robes, pontificating eloquently on some nuance of the law or the other. But my favorite bits about courtcraft have always been those sometimes extended digressions that lawyers take through their arguments in courts, right? And um, in which they'll regale us with stories about, early years of their practice. My lord, when I had just started practicing such and such, or on their daily quotidian experiences of litigation or chamber practice, which was always, as a young intern, it was always a welcome break from hours upon hours of often monotonous legal argumentation, right? So lawyers are also excellent storytellers, as Mr. Gopal Subramaniam's chapter in the book will also tell you when he goes into his recollections and reflections. So I do invite our speakers to bring some of that storytelling to today's discussion, in our own little attempt at building a public memory and an oral archive of the Supreme Court from the people that have inhabited those corridors all of these years. So I invite Justice Hegde for his opening preliminary remarks for 10 minutes. Thank you.
Good evening to everybody. Let me start with the appointment of judges, which itself is a subject matter which is being discussed very strongly. People say that nowhere in the world judges don't appoint judges. May be true, but then who else can appoint judges is the question. Now, when you appoint a judge, you don't call for applications and appointment I'm talking about the superior judiciary. Their performance is observed by the selectors and their recommendation is made based on the information that the judges or the selecting judges have personally gathered it during the course of their tenure in the court. Appointing judges through executive, according to me, will not be a fair treatment at all, because executives always want to protect themselves, so they will be appointing judges who will be in support of the executive. Similarly, allowing the appointment to be in the hands of politicians, I think, is the worst thing that could ever happen. So, in my opinion, only judges know about the future judges' merit and conduct and all. Therefore, they are the right persons to appoint the judges. After all, when you get an executive to be one of the appointing judges, appointing person, is just another human being as much as any other judge is and all. Therefore, you cannot say that judges cannot appoint judges. Therefore, according to me, the collegium system is the best system. They, because of their personal knowledge they have of a candidate who has practiced before them, now will be appointing. Therefore, judges appointing judges, there is nothing wrong, is my submission. The next thing is transfer of judges, which I am totally against transfer of judges. Now, transfer of judges are being done on two grounds. One is the local judges are not good enough to deliver justice and all. Therefore, to substitute that, you send another judge from another court and all, which according to me is not correct at all. There is also another line of transfer called punishment transfer. That judge, if who don't deserve to be a judge in his home state, he should not be transferred at all. And if he doesn't deserve to be in his own state, he should be impeached. Why should send a judge who is of no good character from this court to the other court? So I'm totally against transfer of judges and all. Now, justice delayed is justice denied is the saying that goes around and all. Now, what's happening in our country is something very, very unforgivable. And the people concerned have not even applied their mind in regard to this at all and all. In India, every case, according to me, goes right up to Supreme Court. There was a time when in 50s, hardly 1,000 cases a year must have been there in the Supreme Court. Today, it is more than 1 lakh or 2 lakhs of cases. Why? Because delay in the delivery of judgment benefits one of the two litigants. Therefore, he takes a chance. The first court, he loses the case. Let me take a case of matrimonial dispute and all. Husband and wife, one of them wants divorce, goes to the civil court, and because of the load of work in the civil court, it takes about 15 years and all. Then after the judgment, the losing party goes to the appeal to the appellate court. There it takes another 15 years. Then they go to the High Court. Then they go to the Supreme Court. By the time the judgment comes, husband will be 90, wife will be 85 and all. This is no justice. I don't think by providing multiple appeal or revisional for you'll be doing justice at all and all. According to me, the American system is the best system where there are only two courts and all. First court and an appeal court. You lose in the first court and you go to the appeal court, and if the judge comes to the conclusion is that if he will appeal, then he imposes high cost on him and all. So that speculative litigations don't go higher than the original court thing. So, similarly, there are many other items where if a borrower goes to the court and he is paying 15% interest today, after 75 years, the same 15% he'll get and all. Therefore, you have two courts. Where is the guarantee that after the second court, the third court will justice, or the High Court will do justice, or the Supreme Court will justice? When you do that, the number of appeal and revisions are less, the number of judges are also less. The Indian Supreme Court started with 8 judges. Today they have 34 judges. What for? Now they may ask for benches all over India. a multiple examination of the litigation does not give you justice, according to me. It's just another personal opinion that comes into play. Whereas when it is only two courts, according to my experience, the chances of getting justice is much more. Therefore, there should not be more than two courts, and the litigation stop there. And one of the biggest fear that I have is the underground is likely to take over justice delivery system, which will be the fastest system. If I am a litigant, and so he is also a litigant, one of the underground people will come to me, you want to settle the matter? I say, yes, give me so much money. Then they go to him and said, if you don't agree for settlement, I'll murder your son, I'll kidnap your daughter. So you have to pay the money and settle it is the end of the matter. And that is exactly will be the future of the judiciary in India if you continue to have multiple revisions and appeals. Therefore, in my opinion, one of the problems that we have today is the delayed justice system, which has to be, the way has to be found out. And the only way, according to me, is reducing the appeal and revisional fora. Thank you very much.
Thank you, sir.
Justice Hegde, Radhika, and of course, Justice Muralidhar, who I greatly admire. I have some reflections on the book. Not easy to cover in the 10 minutes allotted to me, but some things spring out to me as someone who's read most parts of the book and attended discussion around the book in Delhi a couple of months ago. One is, as Justice Muralidhar alluded in his introductory remarks, that this is a book that takes a hard look at the Supreme Court. It's not a fair weather, self-congratulatory effort. It's not a coffee table book. It has critical reflections, as the book says, and the sort of reflections that any institution and any profession sorely need. I think it's going to be a trendsetter for a book on the bar, because we need to take a long, hard look at ourselves before sort of pointing fingers at the judicial system. And as many of you know, there have been two resignations at the Pakistan Supreme Court just 2 days ago. Justice Syed Mansoor Ali Shah, who they call Justice Smash, and his letter is something for time immemorial. And it tells you that a crisis can spring up any time, and you therefore need people with character and moral courage at the helm. And I think this book, in many directions, brings the conversation back to that. The diversity of the book you've seen in the introduction in terms of the contributors, the topics, the cartoons, right? They're all very diverse. And I was curious, why just one journalist? But if it had to be one journalist, then who else but Mr. Sainath? Of course, I would have also liked to see a litigant's perspective on what the institution means to them. But on Mr. Sainath's piece, which I read closely, and I read it first because I'm an admirer of his work, and also because he's the only non-lawyer, in a sense, contributing to the essays, there are 2 or 3 things he says in his piece which have stayed with me. One is he speaks of the Bharatpur massacre in Rajasthan, where one of the survivors says that हमारे लिए तो हवलदार ही Supreme Court है. So the Havaldar, or you can call the Havaldar the Tehsildar or the district magistrate, those offices and officers are the Supreme Court. So in many ways, the Supreme Court is out of bounds for the invisible Indian, right? And therefore, there is a risk of the Supreme Court in itself becoming an echo chamber. And when books like this look at it critically, I think they do yeoman's service. The other thing that Mr. Sainath says is that the Supreme Court has really not had a rural bent in its jurisprudence. You've had benches now and then that are pro-labor, left-leaning, etc. But by and large, that rural empathy as a jurisprudence is missing. And of course, it's very difficult to make these sweeping conclusions with the Supreme Court because the Supreme Court does not sit en banc. You have now, as Justice Hegde said, 34 judges, 15 benches, each of which is the Supreme Court. Also, Mr. Sainath pointed me to something that I was not aware, that there is a statue of Manu at the Jaipur bench of the Rajasthan High Court. And apparently, Dr. Ambedkar is somewhere in the periphery. And that was quite revealing, because that segues nicely into Professor Mohan Gopal's piece, which is another compelling piece because he approaches the analysis of the Supreme Court from a caste perspective, which is actually a book in itself. 8,000 words can't suffice. And he uses an interesting phrase that the Supreme Court has been an anti-catalyst when it comes to the redressal or the addressal of caste, especially from within. The sections on criminal law were most interesting for me. It's an area of practice that I engage in, and it was particularly interesting because I think in many ways the crisis and the development of the law also is in that sphere, in the moment that we are right now. The most interesting thing there is that all three pieces are by women, which I think is very refreshing. Three fine counsel, Rebecca Mammon John, who speaks of the need for a principled court, principled in the sense being consistent on principles. Nitya Ramakrishnan, who speaks about the exceptions to all the well-settled rules that we know, that the burden of proof is on prosecution, that bail is the rule, etc. All the platitudes we take for granted, and how they are actually inverted on their heads when it comes to special statutes like money laundering, UAPA, etc. And Vrinda Grover, of course, writes on death penalty sentencing and the overall need for sort of criminal law reform. You had this large-scale process done to introduce new criminal laws, but we really didn't go into sentencing, unfortunately, and this is an essay worth reading. Now, Dr. Muralidhar, as the editor, of course, raises, I think, two important questions for us to reflect on in the course of the book and even beyond it. One is of the what ifs. What if this happened? Agar ye hota to kya hota? I'm sounding like Amitabh from Silsila now. But one of those is what if the dissents of the Supreme Court were in fact the law? I think that's a very interesting and uh, counterintuitive way of looking at things. And if somebody was to pick up just the dissents and assume hypothetically that that was the law of the land, what an interesting conversation and a jurisprudence we would have. And the other is the question as to whether the Supreme Court has really been a counter-majoritarian force. And it's a vexed question. Are courts supposed to be counter-majoritarian at all? Are they supposed to have a political avatar? Right? These are deeper questions one has to reflect on. But there's no doubt that the Supreme Court in India has certainly been pulled into that arm wrestle, if you will. So that's a very valid question and a point of reflection on the Supreme Court in the political moment that we are faced with. And Mr. Gopal Subramaniam's essay, which is of course nice and anecdotal, what Radhika actually wanted, the lighter, off-the-cuff stories and remarks. But he quotes Bernhard Schlink to say something on this point, which I want to quote. Schlink says, once parties, unions and associations, churches and clubs, universities, schools and courts have been forced into line, there comes a point when the ethics of opposition survive only in quixotic, heroic gestures. Beautiful line, and how aptly relevant to this conversation. Ultimately, I think there's a lot of good about the Supreme Court which also has to be said. Just as I said, the Supreme Court should not be an echo chamber. Initially, when I picked up the book, I worried whether the book would itself become an echo chamber, because it's voices like us, the people who normally critique the books, are in the book. So they are now conflicted. They can have no critical reflections on the book any longer. And I worried, therefore, that is it then an echo chamber that the book is? But Dr. Muralidhar has in fact informed me that the book is now in its second reprint. And it's therefore extremely important that the conversation is going out. If it's on a second reprint, these are books that are flying off the shelves. They're not just institutional orders. And that tells you that there's a great curiosity within society, civil society in India, to know about exactly where we are right now and what the Supreme Court is doing. And as I said, there's good stuff to be spoken about. Also, the sheer speed at which the Supreme Court works, the diversity on the benches, the diversity of cases, and of course, the finality, which can be a double-edged sword. But overall, I'm very thankful to be part of this panel, and I strongly commend the book to all of you. Thank you.
Thank you, Dr. Sondhi. You know, something you said really stood out to me, particularly about the section on criminal laws and the fact, I mean, of course, they're all authored by women. I teach criminal law at National Law School. And it's just, we've grown up hearing about how criminal law is not the appropriate domain for women to practice, but something definitely that's changing with time, thanks to the stalwart women before us who have been trailblazers in their own right. But I was just wondering about recently the kind of attention that that bail matters have started to take up at the Supreme Court. And I think in some ways it brings together what Justice Hegde was also saying, right? As a criminal law teacher, I wonder, why is the Supreme Court sitting over bail applications? Is it really the Supreme Court's job to do to adjudicate bail applications, which otherwise under criminal procedure would go to a magistrate or a sessions judge or the High Court? And I think this recent trend should give us pause to reflect not only on the kind of burden that it adds to the roster of the Supreme Court with its expanding jurisdiction, but also the kind of alienation of justice that happens for prisoners, under trial prisoners, right? It's not possible for everybody to go to the Supreme Court. And it also prolongs incarceration for under trial prisoners, which already is at crisis proportions, to have to wait repeated adjudication at different levels to determine whether they will secure bail or not. And of course, there are challenges with listing, etc. But again, as a teacher, I reflect on what does that tell us about the changing dynamics of our legal system itself? And the proliferation of special laws, like you mentioned, and like Nitya Ramakrishnan talks about in the book, right, with UAPA, PMLA, NDPS, which overturn established principles of criminal jurisprudence, and also, as a corollary, burden the Supreme Court the way they do. So, perhaps something to come back to at a later point. But I have 3 questions for the panel, right? And we can proceed one by one, perhaps. And I'll start with something that Dr. Muralidhar writes in the introduction to the book, right? Where he says that, I'll quote, he says that during the 7 decades of its functioning, the Supreme Court has, and many a time deliberately, shaped the political and legal history and thereby the destiny of the country. So I wonder how you would reflect on the evolving role of the Supreme Court in the Indian Democratic Republic over the past 75 years. And perhaps we can start with Justice Hegde and then move on to the others. The evolving role of the Supreme Court over the past 75 years.
Well, when you have people outside the legal services being in the panel of judges, there's bound to be the panel of judges, panels thinking to be brought into the system of selection also. That's why very often you find political leaders also being appointed as judges in different fora. It could be High Court or the subordinate courts also. Therefore, if judges have to appoint judges with a strict mandate that there should be a person who is involved only in the legal profession and none else, then the chances of persons using their intelligence for the purpose of encouraging political views may be less. It cannot be stopped wholly, because every person in India has got certain political views and all. But his character in the profession would have shown whether he is completely controlled by his political views or with the legal views, and such persons can be chosen. But when the choice is left to politicians, then it becomes extremely difficult, the thing, because the politicians want their views to be introduced in the judiciary, and they're likely to be there. Therefore, some sort of an independence from political system should be there in the system of selecting judges, because we have conflicting political systems in this country. Therefore, there should be persons who are not committed to any political line. Bringing in political views in interpreting the constitution or other laws, according to me, is not justice.
Okay, thank you. Dr. Muralidhar, if you'd like to weigh in.
Yeah, I see the question at various levels. One is when I actually said it becomes a powerful political actor. I look back at that 24th June 1975, Justice Krishna granting a conditional stay on Mrs. Gandhi's disqualification. So it's been long debated. If it had not been a conditional stay and an absolute stay, maybe she would have not resorted to proclaiming the emergency. It's a possibility. We don't know. So it had such a huge impact. What followed thereafter, in fact, I was just talking to Justice Hegde. Not many might know that Justice Hegde was the lawyer for the leaders preventively detained in Bangalore. And sir, you should talk about it rather yourself. You don't, you just, because this is what Radhika wanted us to do.
Apart from local political leaders who were detained during emergency here, there was a team of 4 members of parliament who was directed to appear before the legislature here and discuss certain issues. And they were Atal Bihari Vajpayee, L.K. Advani, Madhu Dandavate, S.N. Mishra. They were also detained in the night of 24th, 25th of June in Bangalore. And one Mr. Rama Joyce, a very eminent lawyer, as well as a very good judge who had some political affiliation, was appearing for them initially. He himself was arrested and kept behind the bars and all. So thereafter, not many lawyers were agreeing to appear for them. Then I got an opportunity to appear for them, and I appeared. And I must say that when the final hearing was listed, I went all over India and get most of the top lawyers from India, like Soli Sorabji, Shanti Bhushan, Venugopal, like that, you know. And the Karnataka High Court declared that the declaration of emergency was an act in malice and struck it down. But Supreme Court, as Krishna's interim order said, you know, reversed that finding, and they continue to be in jail here, everything. So I had a lot of contact with them, which of course turned out to be to my benefit, and I became the Advocate General here when Ramakrishna Hegde became the Chief Minister here. He was also under detention. He was kept in, because of spite, he was kept in Ballari jail when his family was in Bangalore, and my family had the right of visiting the detainees once in a week, and all that opportunity was denied to him. And so I moved an application to transfer him to Bangalore, which was granted, the thing and all. Like that, many issues were being discussed and all that thing. But ultimately, by the time they were released and an emergency declaration was declared to be void or withdrawn, or you call it by any name and all, enough damage was done, according to me, at that point of time. The people who had nothing to do with the so-called action against the state and everything, they also were detained. The thing, for example, Rama Joyce is one of them. I wouldn't want to speak about the other detainees for whom I was representing, the thing, you know. So when politics gets into the system, this is what happens. A declaration of emergency was held to be valid because of this prevailing situation at that point of time. That's why people today comment about the integrity of the highest court in India, what they have done in the past and how it has functioned. Everything. Yes, but then it would happen in every organization where human beings are involved. I don't think there will be a court which is 100% free from politics, 100% free from I have known, I'm not mentioning what the background of this is, death sentence, which is a must in the present day context in the thing, were held to be not proper by one section of the people, that there should be no death sentence at all, in spite of the fact the statute says that the death sentence should be there, the thing. Then their personal views come into play. I remember one judge telling me, because I sentenced one person to death, how can you do this? God didn't allow. He is a creator. You don't have the right to send him to jail, gallows, the thing. See, the law specifically says if the crime is proved and the sentence is death, or if for any other reason, it should be this thing. But then the personal feelings of the judges, I suppose, it doesn't disappear. Whereas it is possible, but they carry their personal views into the thing, and this is what happens. That's why human beings, wherever they are, their decisions will depend upon their thinking philosophy and not the law that is that's applicable.
So I'll just add a few things because it's very interesting. Because the judges who constituted the ADM Jabalpur majority felt very bad about it later. And I'm specifically mentioning Justice P.N. Bhagwati because in an interview in 2011, he admitted that he had made a terrible mistake. He should have never been with the majority. But we also have what is called the jurisdiction of atonement. So both Justice Krishna Iyer, who was in the court when the emergency happened, did not utter a word about it. Both Justice Krishna, but fortunately he was not part of the majority in ADM Jabalpur. But both Justice Krishna and Justice Bhagwati were the prime movers of two things. Not only PIL, public interest litigation, but also legal aid. So both of them constituted a committee in 1977, which submitted a report around the time that the emergency was getting lifted, which is the precursor to the Legal Services Authorities Act today. So it's an ironical situation that but for Bhagwati being part of the majority, he may not have atoned. And but for his atonement, we may not have had PIL. But if you shift the cursor, if you shift it now to 2020s, you find the court no less political. Let me take the issue of the electoral bonds. Right? Nobody can claim they did not know what the electoral bond scheme was all about. Nobody can claim that this was a disguised, legitimate form of corporate contributions to elections in secret. So you had corporate funding of elections in a big way in secret without any accountability. And this was happening through state assembly elections and the 2019 elections. If the same decision on electoral bonds had been delivered within, let's say, a few months of the electoral bond scheme being floated, I don't think we are so naive to believe that the results of the 2019 election would not have been different. So there is something here that we need to reflect on. The kinds of issues which it decides to put on the back burner and look at the outcome. See, we were all very delighted. I'm sure Aditya too was. And maybe so you were also surprised when they actually said the electoral bond scheme is illegal. But there was a fine print there, which we all didn't miss. It said nobody need return the monies that have been collected. So operation successful, patient dead. So it's difficult, therefore, to say the Supreme Court is not playing politics or not being conscious of its choices that it is making on the political sphere. Now, third context is 10 schedule. This cartoon that you saw on the Shiv Sena case, the disqualifications are required to be decided first before deciding who commands the majority in the floor of the House. If you postpone the disqualification decision and you say whoever has been carted away to a resort in Goa should be allowed to participate in the floor test, the result is a foregone conclusion. And the Supreme Court is deliberately doing that. Judges of the Supreme Court are asked, sir, don't you want to postpone the floor test till the disqualification is decided? The Supreme Court judges say, no, we can't wait. And what do? 3 years, 2 years later, they actually castigate the governor, saying you had no business calling for a floor test like this. They castigate the speaker, saying you're sitting on the disqualification application for so long. Meanwhile, Uddhav Thackeray is resigned because the writing is on the wall. If there's a floor test, he's going to lose. So they tell Uddhav Thackeray, you're absolutely right, Mr. Thackeray. The governor was wrong, the speaker was wrong. What happened is terrible. It's in fact illegal, it's unconstitutional. But you know what? We can't put you back on the seat. You resigned. So this is again a political choice, right? You know the result is likely to be directly affected by the kind of choices. Now coming to appointments, I kind of agree with Justice Hegde. Judges are human beings. They have their political opinions. There's no difficulty on that. But not everyone is an Earl Warren, right? When Earl Warren was appointed, he was a Democrat. He was the governor of California. Eisenhower was making him straight away Chief Justice of the Supreme Court of the United States. Eisenhower took it for granted that he's going to be a Democrat-appointed judge, and he'll behave the way the Democrat party wants him to behave. He completely belied that expectation. That's why that phase of Earl Warren is considered to be the golden phase of the US Supreme Court, where you told the whole world that the Supreme Court stands by the Constitution and not by its political inclinations. But that's an era gone past. Now, to expect that our Supreme Court judges or our High Court judges, each of them will be an Earl Warren is a bit much. Today, we have a spectacle of a High Court judge resigning as a High Court judge, within a week being given ticket to contest on the Lok Sabha, for the Lok Sabha, on the party ticket. And within a week of his sitting as a judge, he's campaigning actively in the constituency, and he's using unparliamentary language against the opposition. He's pulled up by the Election Commission. So it's very difficult to believe that, this kind of a thing can be easily tolerated. And our Supreme Court judges do not comment on it at all. They should have advised the president not to accept his resignation. According to me, that's one way of stopping. See, there's something called a cooling off period. You may be an active politician. You're coming onto the bench, you need a cooling off period. You have to get rid of, whatever that impact, also not personally. It's about justice being seen to be done. Right? People should see you as a judge who's capable of being impartial. If you were till day before yesterday the spokesperson of the BJP Mahila Morcha, and today you're a judge of the High Court, people find it difficult to believe, okay, on all these sensitive cases, you're talking of criminal law cases, right? Many of these are political dissenters. Umar Khalid is a political dissenter. Let's not even, argue about that. Now, if that kind of a case were to come before the judge like this, it's difficult to believe the judge can be impartial. Justice Hegde, you may be right. A judge may be able to transcend all that and be impartial, but not so soon. The people will not believe that the judge is capable of it. So I think at various points in time, whether on the administrative side, and you know what the judges of the Supreme Court said, one of the judges of the collegium, he said, oh, is it so? We didn't know she was the General Secretary of the Mahila Morcha. Somehow missed us. What do you make of this? What do you make of this? So they are making political choices. They must be called out for that political choice they make. And it's a myth that judges are not political.
And I think that throws a very interesting light on the... And I think what you say throws a very interesting and new light on the question of judicial appointments and independence, right? Because so far the conversation has been about the process of appointment, about the collegium system, the role of the executive in the appointment process, the lack of transparency with the collegium, etc. But the examples that you cite are speaking about a very different kind of interference, right? Where it's not simply about... It's not simply better now, I think. It's not simply about who gets to sit at the bench. But it's equally about where a judge goes after they vacate the bench, and the sort of organizational or political allegiances of members and how that influences their decision making, right? So we always think about judicial conduct must be unimpeachable. It must be the reason why we defer to the judgment of judges is because they bring a certain kind of higher wisdom. and discernment to bear on matters of the day. And while it's true that personal biases and ideological inclinations would affect every individual just as much as a judge, but how do we treat these kinds of allegiances to organizations or political parties that we're now beginning to see within the judiciary? I think that's a question that we can take forward. But what I wanted to ask you, Dr. Sondhi, is a similar question, but from a different vantage point. Uh, you know, how do you think the bar shapes the capacity of the Supreme Court to deliver justice, right? So, like Dr. Muralidhar spoke about, Justice Bhagwati and Krishna Iyer atoning through PILs and the legal aid movement, which is a kind of judicial atonement that I can very much get on board with. But that is very much embedded in the legal profession and the role of the bar. Likewise, Justice Hegde is telling of the emergency and the way that lawyers stepped up or refused to step up also in the defense of liberty. So, how would you talk about the relationship between the bar and the Supreme Court in the capacity to deliver justice?
Yeah, I've now been introduced to a guilty conscience jurisprudence, which I was not familiar with. To answer that question, I will go back to something Justice Hegde said, which was the emergency time experience in the Karnataka High Court, and in fact, in many high courts in the country, where apart from the fact that it was the high courts that showed spine and allowed habeas corpus relief, and the Supreme Court very sadly reversed that law, the folks who were driving that entire fight and were in the firing line were in fact lawyers. Mr. Rama Joyce was mentioned. There were many others who were at the receiving end personally, not just professionally, of that particular time and phase in our history. So there's no doubt that that change has come from the bar. It's not just the bench. And in a
Sorry, Aditya, but you also had the Nirandes.
Of
They are
course
also
we had.
lawyers. Yeah. So I'm saying two sides of the bar.
No, of course. And when doctor speaks of Nirande, he speaks of the Attorney General, and sadly then like a voice ex officio of the government and not somebody who rose above the brief. But I'm speaking here of the private bar that was making the change. And today again you can draw a parallel, because you must have all heard of notices going, summons going to lawyers from the ED. This was something not even thought of till some time ago. And those summons have gone to well respected lawyers, clearly illegal, but it's kind of posturing. And it's the executive pushing the envelope slowly to send a message to the bar to say, stay hands off. Otherwise, you're next. Now, fortunately, the judgment has come. It addresses the situation based on privilege to a large extent. Again, there is fine print there, which I know the executive will pick up and use or misuse in the time to come. But the fact is, why is this being done? Because the executive sees the bar as a threat. And there's no doubt that, just as was the case in the 70s, this is again a point in time where the role of the bar in driving this change is crucial. And it's been there. Your earlier question about the evolving role of the Supreme Court. I just did a talk at the Melbourne Law School 2 weeks ago where I did a sort of a comparative constitutionalism take on India and Pakistan, because that's what my book is about. And the short conclusion there that I tried to draw was that in Pakistan, the power struggle historically has always been between the executive and the military. But in India, that power struggle in the long view of things, according to me, has been between the executive and the Supreme Court. So up until emergency, 30 odd years, you've had a positivist court that did what the law literally read and not what the law should have been, went with the establishment. Then post-emergency, probably the guilt pangs came, and Keshwanand Bharati, etc., happened, where the balance of power shifted completely, which made the Supreme Court the most powerful institution, people say, in the world. And that has again slowly started to regress And you're at a time now where the executive, I think, has, in my view, the upper hand, not only in judicial matters, but crucially, I think, in matters of appointments, elevations, and transfers. So, though the collegium system is there, the ultimate appointments or disappointments are with the executive. And that tells you where things are. So, if you look at things in that perspective, who is fighting the good fight? It's the bar.
According to me, the fault lies in the change of system. If the number of judges in the Supreme Court were to remain at 8 only, then this type of political influence would not have worked. It is because it is 34 now, or 21 earlier when I was there, the choice for people to choose their own people became more. That's the reason, according to me, is the fault in the Supreme Court today. If the number were to be 8 or 9 or 10, then you would choose the best available. When the choice is more, you take 2, I take 2, he takes 2. The merit doesn't count at all. The collegium has 4 members or 5 members, so they'll decide according to their choices, individual choices. So when the number goes up, every value gets diluted. If the Indian Supreme Court were to have judges like the American Supreme Court, not that American Supreme Court is perfect, but the chances for accusing the Supreme Court would have become much, much less. Today, 34 judges in the Supreme Court to hear a rent control matter, to hear pro note case matter, anticipatory bail, which has gone through other fora. I mean, justice loses its value. One appeal, that's more than enough, because to find out if the trial court has made a mistake. Now to choose another fora against the second court has led to the third court, fourth court, fifth court. How much money a litigant has to spend? Where is justice when it is coming after 40 years or so? I was showing a press statement which is in my phone. Nearly 60% of the Calcutta cases are over 50 years. After 45 years, a person was sentenced to death is held not guilty. He's been in jail for 45 years. Why this thing? Just 2 courts will get used to the fact that I got only 1 appeal, that's the end of the matter. But this is a system to please everybody. I still would recommend and fight for only 2 courts for a litigation.
I have another perspective on this.
Don't speak as a lawyer.
So one is, I still maintain that we have not critically analyzed the role played by government lawyers in courts. Now, government is the major litigant in our courts. Government contributes, whether it's the state government or the central government, contributes to more than 60% of the litigation in courts. Government every now and then, whether it was the UPA or the NDA, will come up with some so-called litigation action policy and this and that. Nice sounding words. But government appeals every decision given against the government. And if it was only 2 levels of appeal, again 70% of those cases would be by the government. So government has got what is called litigating capacity. You know, Professor Mark Galanter divided litigants into repeat players and one-shotters. Repeat players like large corporations in the US, like the tobacco lobby, the tobacco corporations have the capacity to keep engaging in the courts till they get the law in their favor. Likewise, the government. Like the government suffered, I would say, a reverse before Justice Pardiwala's bench on the governor's powers to sit on bills. Within a few months or few days, the government managed to get a presidential reference on the same question before 5 years. So the government will keep engaging with the system till it gets the law in its favor. So at very many levels, you have repeat appeals. Add to this contempt. If you decide against the government, the hope of the litigant getting that judgment implemented is another Herculean task. I've had litigants tell me my trouble started the day I won my case against the government. And in each of our high courts, the contempt jurisdiction, the docket is overflowing. So if the government were to seriously consider not filing appeals about a Mali's promotion, an increment or a revision of a pension fixed for an 80-year-old man, all this is carried to the Supreme Court, and what? With delays of 500 days and 700 days. So if we were seriously to critique the role of the government in adding to litigation, in just, in the courts, it would give us a different story altogether. And we're not talking of tribunals.
Yeah.
That's another story altogether. It's the government that created these tribunals. Whether it's the Armed Forces Tribunal or the Central Administrative Tribunal, the government diverts cases from the courts to the tribunals. The government is unhappy with the decisions of those tribunals. The government brings back those cases to the court. So I have a very serious, point of view, a critical point of view on the role of the government in, contributing to litigation. And government, on the one hand, says we have to promote mediation. You'll have every now and then Supreme Court judges wax eloquent on how mediation is the best way to go forward. Government will never come for mediation. It is impossible to get the government to come to a table where they will settle cases, like land acquisition cases. I sat as a Chief Justice of Orissa High Court. I was still getting petitions regarding non-payment of compensation for land acquired for the Hirakud Dam. 1958. So this is what the government is doing. You talk to people from Andhra Pradesh, Nagarjuna Sagar Dam, compensation not paid till today. Yes, most of these land acquisition cases, if they were serious about mediation, in one Loka Adalat, they should be able to settle all land acquisition cases. They just don't do that. So that's my point of view.
So, we're just edging
the government?
closer.
Correct.
People's representatives.
So we're just edging closer to the Q&A. So I think I'd like to conclude this discussion, with my last question, which is, what recent development regarding the Supreme Court over the past few years excites you, and what development gives you a moment of pause and reflection, right? So we'll probably do maybe one-line answers to this question before we open it up for Q&A.
Well, as was said, government is the biggest litigant, and it has never compromised in any matter, except when it came to certain decisions that was otherwise should have been reversed and all. But in my opinion, litigation can only be reduced by reducing the fora. It can never be reduced by any other matter. You can't persuade a litigant to not to file an appeal or a revision because you want some of them gains by the laws, delays with the thing and all. So we have to have a system which can dispose of matters in each court within 1 or 2 years, and that could be only when the filing is reduced and all. Filing can be reduced when there is no fora to be filed. There's no other. You can't have municipal court, civil judges court, district judges court, high court, Supreme Court, and from the sideline you have tribunals coming into the system and all. How many institutions are there to fight litigation? A man who loses in one court gets a stay order in another court. It will go on for years and decades before he could get a judgment in that court. No. Therefore, according to me, right, wrong, or otherwise. Now, how do you know Supreme Court will do the justice after the judgment of the Supreme Court? You must have another appellate Supreme Court. This is a doubt which will be lingering in the mind of litigants. To appease them, if you go on creating appeal and revisional courts, the litigation can never end, and litigation is a curse.
Okay, first the good news. So the cases that give me hope, there are two. One is the most recent judgment by Justice Gavai's bench, which said the grounds of arrest have to be communicated to the person arrested in the language that the person arrested understands. And if that is not done, not only will the arrest be illegal, everything that follows the arrest will also be illegal. Now, this is actually the restatement of Article 22 of the Constitution. But it's taken 75 years for an authoritative pronouncement from the Supreme Court on this. I'm keeping my fingers crossed that every magistrate in this country will follow this. And the Supreme Court will not dilute its own judgment. The second thing that gives me hope is the Sukanya Shanta judgment, which happened in October 2024, which called out caste discrimination in prisons and declared those provisions of the prison manuals which actually legitimized allocation of work among prisoners according to their caste unconstitutional. And it's a remarkable judgment that calls out the so-called Savarna system and says it stands at odds with the Constitution. So this is a remarkable narration that you have in the
Who was the lawyer again in that matter?
No, please. No, but we have a challenge. The court is back. I mean, the case has been kept back for monitoring. Of the implementation has to happen. So I'm the amicus curiae now for that, for the implementation of that. What is disappointing in the recent past is the Supreme Court pausing its own orders. So in Anuradha Bhasin, they said there is a freedom for the internet. It's part of the freedom of speech. So it was celebrated. We thought it was a very progressive judgment. Within a few months, the petitioners came back and said, you wanted them to put on the net all the blocking orders, right? And they've not done that. They've not given reasons. This time, the Supreme Court was told, no, law and order problem, national security. So one hearing went. Next hearing, after 6 months, same story. Another hearing. Third time, the Supreme Court is not even listing those applications. So you have a wonderful judgment, but the Supreme Court does not want to implement it. Now, this is a very, very worrying trend. If you do not want to implement your own judgments, there's something seriously wrong, right? What else are we supposed to do? I'm saying as litigants, as lawyers, you can only tell the court your own judgment is not getting followed. And the court says, no, I'm actually having a rethink. Without actually saying I'm reversing the judgment. So this is a very disturbing trend. It's happened in the Sabarimala case earlier. In the Anuradha Bhasin case, it's happened. So this, I would think, is a bit disappointing.
It's very interesting that all three of your examples have to do with civil liberty, right? Yes. And compared to the very progressive jurisprudence on socio-economic rights that have emerged through PILs, particularly in the 80s and the 90s, the Supreme Court has had a fairly uneven record on civil liberties, right? So there's certainly been the guilty conscience jurisprudence, as Dr. Sondhi put it. But I'll just continue. But otherwise, there's been a fair bit of unevenness on that. But final word from you, Dr. Sondhi.
Yeah. I'll take the second part first, which is the part that troubles me a bit, and it ties in with what you said, sir. Is that we're now seeing this new concept of unwritten intra-court appeals. So we're speaking here of finality and so on, but I see cases where I'm involved and others where a Supreme Court order by a bench of, say, 2 judges finds itself through a miscellaneous application before a bench of 3. And that bench then chooses to stay, dilute, and even in a roundabout way, reverse those orders. Now, this is not an appellate intra-court jurisdiction that the Supreme Court has. But it's happening, and it's troublesome because there's really no finality. There is another thing that troubles me, which is the opacity in the process of appointments, transfers, and elevations. Nobody knows. I don't think the appointees themselves know why they are there or not there. And if somebody is being brought to the court ahead of others, somebody is not being brought ahead, somebody is being given a punishment transfer, all of this is pretty much unfortunately left for gossip in the corridors and not on empirical objective material. And as Justice Sridharan's recent case shows, a good judge being transferred simply because he's too good. On the good part, I won't go into the cases. I will go into a different development, which is the diversity of voices that the bar is now espousing. So young lawyers are coming from a place of their own lived experience, including this prison caste case, Disha, I'm speaking of Disha Wadekar, and many others, who bring not just a voice of equity in the law, but they bring their own life experience to the court. For me, that's brilliant.
Yes, hello. I'm Aditya. I work for a legal journalism organization called the Supreme Court Observer, and we've been tracking this book and also the court for the last couple of years. My one question is about the collegium system because I've heard some praise. I mean, not necessarily praise that this is the right system, but what I see right now is that the collegium system is often dictated by the Chief Justice who is heading the collegium system. For instance, you find that Chief Justice has some kind of transparent approach, giving more details about why a name was considered, why a name was transferred, whereas you get one paragraph recommendations from another judge. If I give the example of Justice Sanjeev Khanna, he released.
Okay, let's.
Yeah, sorry.
Yeah. All right.
No,
so we'll take the question on the collegium.
Yeah.
Yes.
So my
noted.
question is, what is stopping the court from making it standardized? Because why is transparency initiatives being rolled back later
Okay.
on?
Thank you.
Yeah.
Transparency on the Supreme Court collegium. Yes. Second question. We'll just collect the questions and then come to the panel.
Thank you so much for this discussion. And I head an organization called the Federation of Indian Animal Protection Organizations, and the Supreme Court is haunting my every night. So my question is, and with reference to what a couple of you said about a two-judge bench's decision being reversed, withdrawn by a three-judge bench, I would like to go a little back where a five-judge constitutional bench presided over the same point of constitutional law to judge whether a central law was superior to a state law, and did not pass a decisive enough judgment, because of which we are watching a yo-yoing of various judgments. So I would just like to hear what your thought on where is the source of this current problem that we see when it comes to the matter on street dogs.
Thank you so much for the talk and the discussion. I could sound a little bit naive, but I would like to ask this question. I was just thinking if there is a possibility of having a timeline or a schedule for a verdict to be given on the basis of severity of the cases.
So, shall we start with you, Justice Hegde? 3 questions, whichever one you want to answer. Last one.
Seniority should be one of the grounds to take a case out of turn. But there are other types of cases pending, which may be like involving somebody's future, somebody's old age, and other things also are to be taken into consideration. Therefore, seniority alone by the pendency may not be the right factor to confine it only to that and all.
I believe he said severity. And not
Yes, severity of a case is more important than the seniority, according to me. Therefore, but in choosing that, there should be no partisan. You can't think a particular case is very serious and requires urgency merely because either you're interested in the subject matter of the case or interested in the litigating parties. That's what the thing is.
Actually, there's one development that's happened recently. The Chief Justice of India designate, his bench has recently given a direction that all high courts should put on their website judgments that have been pending and since when they are pending. This hopefully will accelerate the pronouncement of judgments. I completely agree. There must be a time limit, and the Supreme Court has said it time and again, but unfortunately, even the Supreme Court does not follow its own judgments on this. There are judgments of the Supreme Court which have got delayed beyond acceptable norms. So there should be an upper time limit. In fact, in the Delhi High Court, there used to be a rule saying date on which judgment is reserved and the date on which the order is pronounced. So that had to be followed. But somewhere down the line, they omitted putting the first line and only gave the second line, which is the date on which the order is pronounced. You're absolutely right. And from the magistrates court to the Supreme Court, there must be timelines on pronouncements of judgments. The question on, the Jallikattu, I think you're referring to the Jallikattu judgment. Street dogs, no. The constitution bench that you're talking about, yeah, that's not a constitution bench. So the thing is this, I think why this is happening, even the same bench, this is Vikramnath's bench, which kept in abeyance the order of the two-judge bench of Justice Pardiwala. This bench has itself had a rethink, right? The first order was to put that order in abeyance. The second order, which has now come, has caused all the anguish amongst all of us. But the point is this: Supreme Court reflects the polarization that we find in society. Right? This one street dogs issue has actually polarized society. You have people who are completely, with animal rights and that position, and there are some exactly opposite point of view, and it's become a political issue. It's no longer just an animal rights issue, it's a political issue. We have to recognize it for what it is. But because the Supreme Court mirrors the polarization in society, you don't have two judges thinking alike. Within the same bench, it's a three-judge bench. It's possible that one judge feels differently, but does not speak out, right? And the other two are able to prevail over the third judge. It's possible. I mean, we've all sat as judges. We know that some negotiation happens on this. But because the cultural diversity that we have, it is for the Chief Justice of India or a Chief Justice of a High Court to be deeply conscious of the nature of the case and make sure that the composition of the bench reflects that diversity, right? If it actually truly reflects the diversity of opinions, then you would have an open exchange of views emerging into a consensus. But that kind of a careful, thoughtful, composition of benches, knowing the possible, biases of colleague judges, that kind of an exercise is not even undertaken. It can easily be explained away saying there are too many cases and how are we going to decide for this case, which judge has what inclination. But there are some very, very important cases in the court, like Justice Hegde mentioned reservations. Let's say the validity of providing a reservation is challenged. You have in your court people belonging to the judges who are other backward classes, judges who are belonging to the scheduled castes, women judges, right? You have a diversity. And yet you compose the bench of all forward caste judges. What confidence does it give to a person that this would be a completely impartial, unbiased judgment? It may be actually, you could say, even if you had changed the composition, the result would be the same. But that would be more convincing. In a democracy, we want our courts to be representative, not just of the populations, but the points of view. So this exercise, every Chief Justice has to be conscious. Every Chief Justice of India has to do a conscious thinking in how to compose benches, or not on every routine daily cases, but all these constitution benches, some issues that are so important for our country.
Say that's one question that's still standing.
Yeah, actually resolutions ought to have a standard format. Unfortunately, this is all pragmatism, right? This is avoiding the difficult questions. So which is why a resolution is reduced to, a statement. Now you have just statements being put out, not even resolutions. So it is a reversal of transparency. And I think the more we talk about it, the better it is. We have to critique it. We'll have to draw a comparison between the collegium functioning in the last 15 years under various chief justices to see where there was increased transparency when where it was reduced. And that's the best way to critique it is, more public discussions and more critiquing.
So my question is very simple. Considering a lot of the recorded footage in courts is being published and being put on online forums, as a common man, how do we make sure that we have lawyers and judges and not actors on board?
Sorry, sir. I think we do need actors. I think we can end with one, a funny episode in court. So this is concerning my own senior lawyer whom I work with. He knows, Justice Hegde knows him very well. So we were before a bench of Justice Venkatachalaya. The case was a very bad case for the client who was questioning an electricity bill which ran into lakhs of rupees. And during the conference prior to the hearing, my senior told the client, listen, you don't have even a 10% chance. If you're very lucky, you might get installments, but there's absolutely nothing in your case. Case was called out, and Justice Venkatachalaya, as is his wont, will not just fling the brief. He will gently place the brief. He will first lean forward. He'll pick up the brief. That's a clear indication that you're out. Next thing is he's going to place the brief down. So my senior notices that, at which point my senior says, "My lord, my client is a poor client." So Justice Venkatachalaya says, "Poor?" He sits back. He says, "Come to page 32. He says, "Yes. See your balance sheet. Just 2 years ago, your turnover was 8 crores of rupees." So my senior says, "Yes, my lord, I'm aware of it. But that was before they engaged me." So the same thing happened in the court. And then Justice Venkatachalaya turned to the other side and said, "Why don't you give him installments?" So you need actors, sir. You need actors to change the mood of the court. And to get justice on your side, sometimes you have to do that.
And actors. And on that point, we'll wrap up today's proceedings with a big thank you to all our panelists.